standpoint, very large.
Yes, Judge.
Yeah, no, and you know, I understand, and that is
You realize that most people at that level, you know, 0.4 is dead,
That's right.
right? You're at a 0.4, you're dead. At a normal person at 0.3, they'd be passed out 3 times over, right?
We're on a Treadwell. This Treadwell is in the jury box. There's a few things to address, Your Honor. There is a bond violation currently right now, and we of course want to address that. I believe it occurred on the 19th of January. Her being, I think, either 14 or 17 minutes late, I guess the curfew. And so when I spoke with my client on this, she explained it as far as what the situation was. This was the Friday right before the big snow, and everyone was going crazy.
Okay, pause. Did you catch that? A bond violation for being just 14 minutes late. Sounds harsh, right? But in the eyes of the court, even minor curfew breaches matter a lot, especially with open DWI charges. What do you think should judges be? Strict about curfew violations when someone's already facing serious charges? Drop your take in the comments.
Of course, we all anticipated like it was going to be the last freeze. So she went to the store to be able to get supplies and load up on all of the necessaries, as everyone felt they should. And of course, the stores are crowded. Traffic is everywhere. Prior to going to the store, my client took her 3-year-old daughter to her 70-year-old aunt's house. And the reason being is because, one, her daughter has special needs and she just does not do well in a social setting. And recognizing that it was just craziness, she had to take her there first. Lines are long, everything, you know. Once she leaves the store, it's apparent that, you know, she very well may not be able to make curfew, but she did have to go get her daughter.
So we only have the one violation at 7:15.
That's correct.
Is that it?
That's it.
Okay. Come up, Mr. Treadwell. Ma'am, it's not the end of the world. I get it. But bond conditions are bond conditions, and you have 2 open DWIs, and you must understand that you and I are operating under strict compliance. And we'll give you a pass now. It's not going to happen again, though. Do you understand? Okay. All right, counsel.
Other matter, Your Honor, we did also want to approach on the court's consideration, or more so reconsideration, of the recommendation for inpatient treatment. Now, you know, we visited this previously.
Correct. And every time I deviate from said thing, we end up regretting it.
And
I mean, 10 times over. So
you shared that with us last time. I do understand that. I at least want to do my client a little justice and at least give them some reasoning behind why we believe outpatient would be a little more appropriate. So the first thing is my client, she has been sober for 103 days. She has exercised diligently and staying committed to sobriety. While she has been released, she has been regularly attending AA meetings, meeting with substance abuse counselor who just had a home visit with her a few days ago. She has obtained her health insurance, which was previously lost due to the loss in employment, but now she can further recovery by taking advantage of the psychiatric care, therapy, and whatnot. And 2, and this is really primary, the family circumstances. The circumstances of the family are the type that requires my client's presence at home. She is the primary caregiver of 2 daughters, ages 10 and 3. The 3-year-old, as we shared before, is a special needs child. And when she was in custody after the second offense, it was her parents who did take care of the children.
So luckily we have that going.
Well, yeah.
Have someone to watch the kids.
Yeah, and that was for just about 30 days or so. Definitely operated as a hardship as to the parents. And of course, in these kind of situations, there's going to be sacrifices. Sacrifices has to be made by all parties.
This is where things get real. The defense is painting a picture of a struggling mother trying to hold it together for her kids, one of whom has special needs. You can feel the emotional weight here. But remember, the court's concern isn't just about hardship, it's about public safety. The tension between compassion and justice? It's front and center.
But we're talking about now 180 days, 6 times that amount, which, again, I think it would be a tremendous hardship. And particularly with, I think a lot could be said about it, but particularly with the special needs child, what we do know about that demographic is they need routine. Routine is keen in their lives. If that is removed, it's, they could get discombobulated and it could operate as a crisis to them. So what we do know is if she does have to go to this outpatient program, home is no longer going to be there. They're going to have to move with whomever.
You say she doesn't have health insurance?
Oh, she does. She does now. She obtained it as of July 31st. July 31st, right? Yes. I'm sorry, January 31st. Excuse me. But yeah, so they would have to move. They would have to switch schools, just uprooted from the life that these girls do know and understand. And again, particularly with the special needs one, possibly not even be able to attend, is it occupational therapy? Occupational and speech therapy. Thirdly, Your Honor, when early on in this case, I had informed the court of my client, she is prescribed Adderall. And at the time of the offense, during the time of these offenses, her therapist had, they were adjusting her meds, even had her on an extremely high dose of Adderall. And, I don't want to portray myself as an expert in this at all because I just found this information out. And that is that Adderall with alcohol, of course, that's a bad idea already. Okay, but what it does on a molecular level, they're both fighting for enzymes, and the enzymes are what's extracting it, getting it out of the body. The effect is that they mask each other, and so someone that is drinking while on Adderall, they're drinking, they're not feeling the effects. They're drinking and drinking. Your body is not telling you, okay, hey, we're intoxicated, but all the while, of course, the blood alcohol levels are through the roof, even to a fatal level in some instances. The blood alcohol levels here they're up there.
How high are we talking?
We're talking high, Your Honor.
And the point of very low extraction.
Yes, Judge.
Yeah, no, and I understand, and that is.
You realize that most people at that level, 0.4 is dead.
That's right.
Right? You're at a 0.4, you're dead.
Let's break this down. 2 separate DWI cases, one with a 0.28 and another hitting 0.3. And if you didn't know, a BAC of 0.4 is considered potentially fatal. That's what's driving the judge's decision to stick with inpatient treatment. It's not just punishment. It's a life-saving intervention. Now the clock's ticking. 45 days to sort everything out or face trial.
A normal person at 0.3, they'd be passed out 3 times over, right? It's to be able to get to that level at a 0.3 and then a 0.2 on that truly tells me that there is an issue there.
Well, absolutely.
Right? And me, with that kind of levels, right, and we have 2 open DWIs, if I don't follow the recommendation, because that's why we have these people. They're clinicians, they're experts in what they do, they make the evaluation, they make the choices. I understand it will create a hardship, but sometimes that's what needs to happen to gain perspective and to gain knowledge. I understand your plight. I understand your position. Every time I deviate, you regret. She has a 0.3 and a 0.2. What was it? 2.8. A 0.28 and a 0.3 on 2 different DWIs.
That's correct, Your Honor.
I'm sorry.
Well,
Just,
and again, I know that
I understand.
That is
I'm never going to be
attributed
a lawyer for, zealously advocating, and I appreciate it. And you have to do what you have to do. I understand. Sorry. It's too much. If it was a 0.4 or a point, 1.4, but we have a 0.3 and then we have a 0.28. Really, it's too much. I don't know how you want to move forward, but I am sorry. I don't want to deviate from it. We can give you time to make arrangements, but I think that that's the appropriate course of action. I'm sorry, Ms. Treadwell, because there are consequences to actions, right? And I know that it's going to be hard, but I think it's going to be all for the better.
Your Honor, I absolutely agree that, when we're talking about treatment, who can speak against that? And I do understand that.
And I mean, we're giving it to you for free. You get out there, you're going to have to pay for it on your own. You're going to end up thousands and thousands of dollars to pay for it. I can't pay for treatment on the outside. I'm telling you, I know that you have insurance. Insurance is only going to cover a portion. When you go to these outpatient treatment programs, they're thousands of dollars.
There is also the KEYS program and the Access program that,
She's a 0.31 and a 0.28. Really. That needs a lot. That's why they recommended it. And I'm sorry, but, I wish I could make a different decision, but sometimes we have to make tough decisions as well, and I'm sorry, Ms. Treadwell, but, I will give you as much time as you need to make arrangements, but I truly think that that's the best and appropriate course of action. Okay.
How much time?
I mean, your first case is... Your second case is 104 days. The first case is 153 days. So you've got some time, but I mean, we're running up against it. I'll give you another 30-day setting. But that's it.
Your Honor, would we bid in 45 days? Because there's going to have to be some major movement that is done on her end to even try to get someone and make arrangements for the
I will give it to you, but that's it. I mean, really,
I get it.
At the next setting, it's player trial. I'm not going to play this game. I will give you the 45 days, but everything needs to be done by that time. Okay?
Yeah.
All right. Sorry, sir. Please.